So we have now this morning session with a member of the European Parliament, and we are going so to have the point of view from inside the Parliament about the new Pact on Migration and Asylum presented by the Commission. And I am therefore very proud to welcome this morning Mrs. Tineke Strik, who is a member of the European Parliament, a member also of the Libe committee, and who has been elected on the list of the Greens. And she is actually a Green member of Parliament elected in the Netherlands. I will not go further to present her because you know also Professor Strik as she came to teach in the summer school, and we are always very grateful for your contribution, dear Tineke, and also quite proud that in the Odysseus network we have now a former member who is a member of the MEP. We have also a member who was a Minister of Interior in Portugal, and another one who is a judge at the Court of Justice. So actually, it's good to be a member of the Odysseus networks because it can sometimes help you to, well, I don't know. Sometimes we are just lucky, it's the country Odysseus having bright people among us. So, dear Tineke, I wanted to ask you a certain number of questions, knowing that you may have to leave us at one moment because of your schedule in the European Parliament. You accepted to participate in the middle of a plenary session in Strasbourg. The first question that I wanted to ask you is what is your role for the moment regarding the Pact in the Libe committee? As I don't know if you are a rapporteur, shadow rapporteur, a coordinator, or you certainly also have a certain influence because you are extremely active. So what is it about your role in Libe for the moment?
Yeah. I'm coordinator for the Greens, indeed. So I'm member of the coordinators meeting where the Libe committee decides on procedures, on activities, and so on. I'm also rapporteur for the recast returns directive. It's not directly one of the files of the Pact because it was already on the table, but now with so many return provisions in every file actually, returns directive has become even more important, and we therefore also treat it as a part of the Pact. We have, in order to ensure a horizontal approach, to have a consistent approach, we have an asylum contact group consisting of all the rapporteurs of the different files. And we have made sure that every political group is represented there. So even if they do not have a rapporteurship, then they can have a representation with one member. And there we discuss elements like what are the cross references, what are the maybe the issues that may rise, if you look at the different files altogether. We also need to have discussions there. We already discussed them on do we keep the package approach. This was approach that was adopted already in the previous term by the Parliament, saying that we're not going to adopt any of the files as long as the whole Pact is not already agreed upon. Because what you see in the Pact, of course, that every file is beneficial to a part of the member states, but not, but it's important that member states are obliged to also accept then the other parts, because otherwise it will be even more difficult to get everything adopted. Actually, next Monday, we will have this discussion in the Asylum Contact Group to see how are we going to proceed if the Council comes with a request to go ahead already with one of the files. even if the rest is still under discussion. We had this, for instance, with the Asylum Agency. I just told you before it started that the Council really wanted to have the stronger, improved mandate of the Asylum Agency, because it would mean that more support can be given to the countries under pressure. Of course, we were very sensitive to that argument, because there is a lot of need for more support from the agency. But on the other hand, we want to ensure that that it doesn't create more difficulties to get adoption of the other files, and also that it would create a precedent for departing from the package approach. It has now agreed with the majority that we go ahead, that there is a trialogue, and that there's already an agreement. Although some, for us, important elements are postponed. So they are in the regulation, but the application will only start once the Pact is adopted, which I think is problematic. But next Monday, because I was just given an example, next Monday we will have the same discussion on Eurodac, where there's also, especially the rapporteur, he's an ECR rapporteur, really wants to go ahead, make sure that this also remains part of the package. So there we have discussions. What we also had there sometimes is the Commission and the Council coming to explain the state of the play of state in the negotiations. And as you probably are aware of, there's no impact assessment for the new Pact. And this is what we really criticize a lot, because we want to see how it will work in practice and how all those different files act together on the ground. And because of this criticism, and also from the Council, the Commission made a simulation, and this simulation was presented in the Asylum Contact Group. So all topics of common interest are being dealt with there, strategic discussions, and also on the content, so that we know how all the different files go all together. For the rest, I'm a shadow rapporteur in the screening regulation. And what we do in the Greens, except for what I now said was with all political groups, but in the Greens we also have a subgroup on migration, where we every week at the moment actually take one issue, one theme, and then look at how it works out in the different files of the Pact, and then come up with our own position and also strategically, do we need to reject things or come with an alternative, or, how can we strengthen certain things? And this is very useful, I think, so that every Green shadow rapporteur is also aware of the whole context. Okay. Now, if I'm well informed in terms of progress of work in the Libe committee, the rapporteurs have been appointed. We don't have yet, of course, reports, not even a draft report, but things will move normally in September, when the Parliament will resume after the summer. Do you expect that there will be then a quick progress with the work of the European Parliament about the Pact? I guess it may be just as difficult as it seems in the Council. No, what we did, because we had this criticism that how does it work? We had a lot of questions, legal questions, practical questions. So we decided to undertake a substitute impact assessment. And the results are almost there. So they are, I hope in July we have seen the first draft, but it's not yet ready yet. So just before the break to have our own study actually on how it works. And we thought that this would be important before we are going to already come up with a report and amendments. So some rapporteurs indeed envisage to have a report in October, in September, others in October. Then, of course, there will be a new deadline for amendments from the shadow rapporteurs, and then the negotiations will start. Yeah, I think there are a lot of on the one hand, you can say that if you look at Dublin position of the Parliament in the previous term, we were pretty united. We were much more united than the Council was by insisting on an equal responsibility sharing. And actually, we really favored the idea of that there should be a kind of automatic division of asylum seekers, at least at the moment that the country of first entry already fulfills its quota, so to say, that then the rest should be automatically divided or reallocated. I really hope that we will keep this position, because I think it's a very important one, because without an equal responsibility sharing, we also won't achieve any harmonization of the asylum policy. I really believe that, maybe on paper, but not in practice. So let's see. This is also really a test, because political groups are also linked to member states, governance, etc. So this also influences their position, of course. And there are clear divisions on political differences and positions on the screening and on the border procedures. For the moment, on screening, everyone is a little bit negative because of the uncertainties around screening. How will it work? But I think in the end, ideology will lead to some more, the right groups being more in favor than the progressive groups, I think. The same would count for border procedures, I think. So there, on these topics, there will be more division if it comes to the AMMR or the RAM. I think that everyone really criticizes the bureaucratic procedures and the lack of guarantees for the border countries that they will see a relief of their responsibility for asylum seekers. I think also on return sponsorship, the positions are also a little bit divided, although no one knows how it will work in practice, because so many things are uncertain.
Okay, well, you just mentioned some difficulties in the work. Well, it's clear that in the Council it will be extremely difficult, because there you have national divisions and east, west, north, south. In the Parliament, it's quite different, because the dynamic is based on political groups. But you seem to expect also some difficulties in order to negotiate between left and right, and you can only find a majority actually in the center. Without the center, you don't have a majority. Would you also say that it could be more difficult during this legislature to make compromises than during the previous one?
Yeah, the interesting thing is, of course, that in the previous one there was a big coalition, so to say, that EPP and SD together had a majority. So if they found a compromise, it was, it was agreed upon, and all the rest could just say yes or no. This has changed with this term because they don't have a majority anymore. So they rely on other groups, on the support of other groups. You see in many cases that EPP, SD, Renew and the Greens are the most, determining that the dynamic is really between those four, because the other, more to the left and more to the right, they mostly stick to their principal position. So it's the dynamic is between the four, and what you see is Renew is has many faces. It's not clear cut what their position is always, because these are the liberals, and how conservative, how progressive they are really depends on the political party they come from the member state. For instance, in the Netherlands, two political groups are represented in Renew. One is really the social liberals, where Sophie in 't Veld is a representative of, who is actually almost in line with my position, so to say. But then there's also the conservative liberals, Walik Asmani, for instance, who is in the same group, but is really on the line of the EPP. So this shows a little bit that it's sometimes unpredictable what will happen. And what was therefore interesting and important is that already before the Pact came out, all the political groups released their own position paper to see where they stand regarding responsibility sharing, border procedures, and so on. So this gives a little bit more insight into where will they stand with those different files. And there you see, for instance, that Renew is in favor of a border procedure. And therefore, I think that a majority will support the idea of a border procedure, but not how it would look like. You know, that depends also on what is the scope, who should be processed in a border procedure, what safeguards will there be, etc., etc.
So that's very interesting. Now about one of the hottest issue, Dublin and solidarity. When you compare now what's happening with the past, the previous proposal of the Commission of 2016, and then the Wikström report that the Parliament made by Mrs. Wikström, you can see that actually the current proposal is certainly less ambitious in terms of relocation. And on the other hand, you seem also to doubt about the possibility to make sponsored return function. And actually, honestly, you are not the only one. We heard during the opening session of the summer school that one person even said that sponsored return will never work. So what can be done about solidarity, which is actually a key issue, because the southern member states will never agree about the pact without strong solidarity, but it doesn't seem so promising. We have a relocation mechanism which is not very ambitious, and we have maybe a sponsored return mechanism that will never work.
Yeah, exactly. You touch upon the right point, Philip. It's on the one hand, it's very bureaucratic and unpredictable how it will work. But the main problem, of course, is that there is mandatory solidarity, but there's no obligation for member states to take over asylum seekers. And what we saw during the last years, if you will treat that as a possibility and not as an obligation, there is hardly any relocation. There's hardly any offer by the member states. So that will mean that border countries rightly so fear of being stuck with a lot of asylum seekers, maybe in the border procedure, because there everything, may stop if you have long waiting lists and too many people to process. So yeah, I think actually that this is the key issue of the whole asylum policies. I mean, this whole principle that the country of first entry is and remains responsible means that there's no equal responsibility sharing, means that they run the risk of going below the standards of our rules, or not completely fulfilling the obligations, means the difficulties for other member states to send back people, means secondary movements because people, are waiting there in substandard conditions. So you will never get a harmonized system in practice if you do not regulate an equal responsibility sharing. And this pact, actually, Johansson says it's better because there's mandatory solidarity, but if you can also give money or deploy civil servants, then why should you fuel maybe a national debate that you don't like by inviting asylum seekers? This remains the most important problem, I think. The Commission, of course, in 2016 first wanted to come up with a proposal of automatic division. This was immediately rejected by the member states. So they, Johansson really wanted to come up with a position, with a proposal that could be adopted. But I really have the feeling that she really wanted to have a consensus on the pact. And maybe that was too ambitious. Maybe therefore she took too much into account the Visegrad countries, for instance, which you can never satisfy. You also see it now, because I think because of the Visegrad, you got this return sponsorship, but they say no way that we are going to allocate irregular migrants. So you will never have them on board. But if you would have, tried to get sufficient member states on board for a qualified majority, it could have become more ambitious, because, now countries like the Netherlands or Germany, etc., can hide behind the Visegrad countries. But if it really comes to voting and to make the system work, they would have perhaps agreed with a more mandatory relocation obligation. We don't know, it's not on the table now. But therefore, I think, because it's already so low, the level, and that you already see now that member states are trying to even make it lower, that always happens, that we will end up with nothing, or we will just end up with no agreement at all. Because what you said in the beginning already, the southern states want to have more guarantees for relocation. The other member states want to have more guarantees for the southern member states on screening, so that everyone is registered, so that no one can simply travel further without being returned. And they want to have more guarantees on the border procedure, with a lot of human rights concerns, that many people may end up for a long time in detention at the borders. So they have really opposite. And if they keep each other hijacked, we may end up with nothing. And my concern is actually that this is already the case since 2016, with the first proposal on the new pact, which led to negotiations for years ending in a deadlock. But at the same time, a lot of rules that we had already adopted are simply not complied with. There are huge gaps in the compliance, especially at the border, of course, with the pushbacks, but also reception conditions and so on. And there's no enforcement attempt at all. There are no measures, no infringement procedures, even no outspoken position from the Commission that this is unacceptable. And because maybe the Commission needs also the southern member states to have them on board and to keep on negotiating. So this is not a comfortable position, then at the same time playing the role of the police agents, perhaps. And this is what I found really disturbing and concerning, that we will now going to have negotiations for years again, while the violations are only getting worse at the borders, on the territories and so on, and that there's no compliance or enforcement at all. So I would rather than see, if we do not get rid of this first entry criterion at all, because it's still in the pact, why not leave, why not just simply start working with the rules that we have and make sure we have a proper implementation. We may then have, in the end, a better harmonization, better guarantees for asylum seekers than endlessly trying to get an agreement on new texts.
Thank you. That's again a very enlightening explanation. But don't you think then, if we, I think it's understandable the position that actually the pact is not possible, so let's stick on enforcement of the current rules. But due to the fact that we have externalized the solution with transit countries like Turkey or Libya, is there then not a risk that if one day we have a crisis which is more or less similar to the 2015-16 one, that the system will once again collapse?
Yeah, for sure. I think the system has already collapsed, sort of. I mean, Germany only started to call for a new pact once she noticed that most of the asylum seekers were in Germany, that they asked for asylum in Germany, so they wanted to have an improved system in the southern states. So I think it's already not working. And indeed, we need to tackle this externalization at the same time. Because I agree with you, actually you see two parallel developments. The member states do not agree on anything if it comes to internal legislation, but they completely agree on everything if it comes to outsourcing responsibilities to other countries. That goes very smoothly, actually. And you saw the EU-Turkey deal, which was concluded in a few months' time. You see the support, the financial support of the Libyan Coast Guard with a lot of human rights risks and effects, which is not raised, not taken into account. It just continues. We see that the conditionality has changed from more to more positive incentives to less for less, more sanctions. And we really should tackle this at the same time. It's not externalization, it's not a solution for our own responsibility that we have as a member state. No, on the contrary, if we keep on outsourcing our own responsibility, what then do we do with the global compact on refugees that we committed to a few years ago, saying it is a common responsibility globally that we should also take our share? And that's what we simply do not want, apparently. Because of these concerns, I wrote a report for the Droit Committee. This is the Human Rights Subcommittee of Foreign Affairs, on the human rights implications, on the human rights aspects of the external dimension of asylum and migration policy. This report was adopted a few weeks ago, and there the European Parliament demands for more assurances that the external dimension is human rights compliant, and therefore we call upon a human rights impact assessment before entering into cooperation for transparent and independent monitoring system, so that we can see what the impact is on the human rights. For instance, if refugees get stuck in a transit country with no access to protection, democratic and judicial control. That means it should be formal agreements and not like these statement and the joint way forward and all those, blurry arrangements that the EU is now making. And there should be much more scrutiny on the funding, on the implementation of the funds regarding this. It were difficult negotiations, but we have it adopted. And now it's the moment for us to build on these principles. And the next debate I have now on the EU conclusions, where also the EU Council decided to come up with new funding for Turkey, actually a kind of prolongation, consolidation of the EU-Turkey statement. I will remind the Parliament of the principles that they adopted, and that we should also, watch, not only watch, but really actively engage in this development. Because this is also one of the difficulties, I think. This is just Commission and Council. Parliament is nowhere, because it's not a formal agreement. And we can ask Johansson for information or Upri-Lainen, but we are simply sidelined. And I think that this is really not acceptable in these times of, that we want the EU for the citizens and so on. But also because our competences are also on the negotiation table often. We have our competence on readmission, for instance. We need to give our consent to readmission agreements. And what you see is that the two other institutions are informalizing this, but make clear agreements on readmission with third countries. So I think this is really unacceptable. I don't think the Parliament would immediately change its attitude with the adoption of this report, but for me it's an important basis to go further with that. After the summer, we will have a hearing in Droit on Libya. Amnesty will release a report mid-July on the situation of refugees and migrants in Libya. OCHR recently came with a report, Lethal Disregard, also on Libya. And we heard from MSF a few weeks ago that they decided to withdraw, to stop their work in the detention centers in Libya, because of they were only taking care of people with broken bones and huge wounds as a result of being tortured by the Libyan militias ruling those detention centers. So we really need to raise this awareness that this is an EU involvement that we can no longer accept. So now I try to build cases on the basis of the report that the Parliament adopted.
Thanks a lot. That's indeed a very important element as well. Well, before turning to the audience, I have one last question just in relation with what you said about the EU-Turkey deal, which is very controversial politically, but also legally. How can you explain that actually the Parliament has not decided to introduce before the Court of Justice an action for annulment of the deal on the basis of the fact that its consent prerogative has not been respected, and knowing actually that the Court of Justice requires, even for soft law, the procedures to be respected. I find that a bit strange, because actually on a very important point, violating its prerogative, the Parliament is actually not going to the court.
Yeah, I agree. This is something for, I really go to try now with this report, with the conclusions of the Parliament, try to get a majority for that, also making use of our litigation powers. But here it's again, it's a very strange. What you see is that the Parliament plays an important role in deciding whether to go to court or not, or whether to join cases of other institutions. And there they seem to have made a kind of agreement, like we are only doing that, if our own interest is at stake. Now, here you have our own interest, I think, because it's your own institutional role. I think we should go to court more often, like also in rule of law cases, that we really make our position more legally. But indeed, it seems, but I'm not member of the Jury Committee, that there a majority is always on the let's say the political spectrum, the right side of the political spectrum, and that they are very conservative in that sense, that they don't want to undertake action easily. So that they, and in the sense, if that's the case, they just they don't want to form an obstacle for the governments that want to undertake action at a certain moment. And this, of course, is very harmful to the position and the credibility of the European Parliament, because we have our own prerogatives, as you say. And I think that it's for us very important to foster the checks and balances that are so much needed. Not only democratic control, but also judicial control. You saw it with the Court of Justice saying, I'm incompetent if it comes to judging on the EU-Turkey statement, because it's something between the government leaders and Erdogan, which is, it's incomprehensible. But we should support the court, make sure that, they are not coming in such a difficult position. But these are just formalized. This is, I think, very important also for victims of such arrangements. And I think we will get more and more of these victims, and they should be able to go to court.
Thanks a lot. The clock is running, and as you may have the need to leave us a bit earlier than 10 o'clock, I propose now to turn to the audience, mainly participants online. And so I want to ask if some of them have a question for Tineke Strik. Please raise your hand. There is one hand, Elsa Fernando. Yes, please, Elsa, go ahead.
Can you hear me?
Yeah.
Yes.
So my question is indeed related to these soft law agreements that you just mentioned. I'm quite worried because the agreement with Afghanistan was just renewed, and the situation in Afghanistan is getting worse, but it may be also the future of Ethiopia, with who the European Union also has an agreement. What is the projection? What would be, for example, the hypothetical opinion or potential activity of the Parliament in 2 years in related to soft deals with these countries where huge or really dangerous breaches of human rights can be concluded?
Okay, let's maybe collect, if you agree, Tineke, 2-3 questions to make sure that people can speak. So we have also Caroline Pop.
Good morning.
Morning.
Can you hear me? Yes. Hi. Thank you for spending so much time on us this week, these 2 weeks. My question is perhaps a step removed from the content and the substance of the Pact and EU migration policies, and it's rather about the role of the citizens and those the EU as the parliamentarian of the only elected body of the European Union. So what I often ask myself is, as a concerned EU citizen with a strong interest in migration and asylum, what can I do to make my views on this heard? What is useful? What is helpful also for the parliamentarians? So concretely, do I send you an email? Do I write to my own representative in the European Parliament? Do I tweet you? I don't know. Like, this is my question: is what, you know, we're sitting here, we're learning about all these things. We find a lot of the developments concerning, but how can we, as the European electorate, actually make a stance or influence, if at all, those discussions? Thank you.
Yeah.
Thanks a lot. And then let's take one last question of Caterina Rodelli. Caterina?
Yes. Can you hear me?
Yes.
Yes.
Good morning. I have a technical question. I was very interested when you say that the Greens commissioned a impact assessment on the Pact, and I found it quite interesting that you would use an independent tool to assess the consequences of the Pact. So I would like to ask you who conducted this impact assessment, if it is a common practice that political groups have to check the effects of the Commission's proposals. Thanks.
Thanks a lot. That's the first round. So, Tineke, one question on soft law, Afghanistan, one about how to help the EP, and then another one on impact assessment.
Yeah, the whole range is covered now. Yeah, thanks a lot for these interesting questions. What do I expect within 2 years? I'm only for 2 years now in the European Parliament, and what I notice is that the pace is very slowly if there are big interests at stake. That you won't change things easily and also not quickly. This is why I thought of the strategy of first having this report. That was already not so easy, actually, but we have now this principle, then build cases. And also, if the Commission, because it's not legislation, so we cannot enforce things, to build pressure by, this report was already creating pressure, I hope. We said to the Commission there should be impact assessments and there should be monitoring system. I think that because I'm calling for monitoring now for 2 years, that if it doesn't happen, it would be interesting to see if we could organize monitoring ourselves, if we could create a network that we inform ourselves, and not we as the Greens, but as the Parliament, that we organize hearings once in a while or whatever, that we have the persons there, experts there, explaining to us what the impact is of such soft law arrangements, in order to increase the pressure and the awareness of the European Parliament that we should do something more with it, that we should not let it go. And on the other hand, try to indeed build the case legally clearer. So also making clear that, it's also dangerous for the European Parliament to accept that Council and Commission take away our competences, because this may also have an impact on other areas as well. So actually try to build the arguments for the other political groups also to, at a certain moment, say, stop, this is not, we need to also undertake litigation. I think this is important. What we can already do now, and this is what is now also happening, is organize a better scrutiny of the funding. I'm also a member of the Financial Working Group in AFET, and they're like the Trust Fund for Africa, IPA funding, all types of funding are being discussed there. We get information from the Commission, we have questions and answers, and then we know better, we are better informed, and then we can better undertake action. Now for NDCI, because this is a new big fund just adopted, where the former EU trust funds are included, and all other funding for development aid and other areas, where we fought hard to make sure that conditionality on migration does not cover the whole fund. It's now has become only 10% that can be made conditional upon migration cooperation. And the migration funding as such is only limited to 10% of the whole fund. So this is really what the Parliament wanted. And now, as a result of the adoption of NDCI, we have strengthened our framework to scrutinize the implementation, because we have demanded or negotiated that there are delegated acts in these funding. So at a certain stages with large amounts of funding, there needs to be a consent again from the Parliament. And therefore we organize now a stronger structure so that we can really see what is happening with the money. And very important, because I'm also a member of Libe, therefore I'm a member of AFET and Libe at the same time, in order to have this comprehensive strategy. I will also link it to human rights impact, of course, and I will specifically look at the human rights impact, and that may hopefully lead to new demands from parliaments or whatever. But we are sidelined, and we cannot simply just make that undo that. We need to use all our different strategies that we have, both politically and legally, but also for legally, as I explained, we need the political majority to take those steps. So yeah, I do not expect that a lot has changed already within 2 years. But what I do hope is that there are much more awareness, more transparency, and that we can really exercise more influence on these policies. Regarding the question of Carolina, what can we do? A very good question indeed. I think that's so important, that we are representing people. But what do people think about these policies? This is also what you see, that governments, leaders always refer to, for instance, a lack of societal support in their countries, and therefore they cannot, agree with obligatory relocation or whatever. At the same time, we see, and I think that's very important, that there are many movements on the grounds, like Europe Must Act, Welcoming Europe, showing that there are many cities, municipalities, people, movements who really want to have another attitude, who want to get rid of Moria situations and want to have an equal responsibility sharing. And this is of vital importance. Because then, the argument falls away of the government saying that there's no societal support. So if you see these types of actions, it would be great to support them, because it's just a matter of people working on it. Sometimes, a small group trying to get a big impact. That would really be helpful. And I would say, if you follow the developments critically, of course, you can always reach me, but also try to convince the politicians who are not convinced yet. So who are critical to certain demands on solidarity or whatever, trying to convince them, and not specifically the right wing like ECR and IDEA. I don't think you can influence them effectively, but in the middle group, I think it's very important that they also start to understand that society wants another voice. Society perceives migration as normal and sees protection also as our obligation. I think that would be, so in that sense, I think public opinion is of vital importance, and every person can influence this public opinion, even with his or her opinion. So this is what can be done. What I try to do in my own work is I have built a website. It's called Inside Out, to make everything what is happening in Parliament more transparent. So I publish a lot of documents on that website. I write blogs, and really trying to explain better what is happening, what's the state of play, so that people can more easily become involved. And the same issue is with transparency of documents. Too many documents are still not disclosed and not for a justified reason. So what we also try to do is put pressure on a more transparent decision making, which makes it more easy for public, for individuals to follow what is happening and to then influence it. And don't forget your national parliamentarians, because we are democratically elected. Indeed, we are the only institution in the European Parliament, but still it's up to the members of the national parliament. I was a member of the national parliament for a long time, to influence, to control and influence the position of their ministers in the council, because the council is really sometimes still a problem also for us. And let them be more transparent and be influenced. So the debate for the council should really take place in the national parliaments as well. Then Katarina, on impact assessment, maybe I was not clear enough. The impact assessment is undertaken by the whole European Parliament. So we decided as an asylum contact group that we needed to have our own asylum impact, a substitute impact assessment. Asylum contact group consists of and this is actually a big problem we see with the whole asylum and migration area. In every directive, you see the obligation of evaluation reports, implementation reports, let's say every 3 years. We have a whole list now of directives which have not been evaluated anymore since the last 6 years. So we don't know how it's being implemented on the one hand, and then we don't know what the impact is of new legislation. The European Court of Auditors also criticized the Frontex regulations for the same reason, that we don't make evidence-based policies anymore. So this is really to be criticized. And therefore we said, okay, we do it ourselves, but it's much more limited than what the Commission can do with a much longer term study and involving all the information from the member states. This is a research department of the Parliament. So we give the order, but they are working it out, and they are also using procurement rules in order to get researchers doing the work. I know Odysseus network is also a participant often in tenders and in working for the European Parliament. But what individual MEPs can do, and sometimes as a Greens we do that, is we have a budget for doing studies. And then we can also ask someone to undertake a study. But again, the procurement rules are also applicable to us. So beyond a certain limit of funding, we also work with tenders and so on. We did such a big study, for instance, on the impact of the COVID-19 pandemic on rule of law, asylum and migration, etc. And of course, we published the study results as well. And now we also did it with the rule of law. We asked some researchers to, because the Commission says, well, there are some difficulties with infringement procedures. We asked experts to make a whole, let's say, a document that the Commission could immediately use in order to go to the Court of Justice. So to take away their arguments actually on hurdles, for instance, Article 2 of the treaty, that they cannot immediately use it in cases. So we can use it in many different ways to get more information on effects, but also in a strategic way to use it to get something done.
Thanks a lot, Tineke. Please tell us when you have to leave, because you.
Yeah, I will ask it. Yeah, shall we approximately 9:30 at least? That it's
sure.
Just one small round. Yeah.
Yes, a small round of 2-3 very precise questions that you can answer quickly and easily.
Yeah.
Please raise your hands. For the moment, I don't see any hand coming up. No. Yes. Again, Katerina.
Yeah, it's me again if there is no one. But I don't have a specific question, so you're free not to take it into account. But maybe we could close with, yeah, what is your view on the pact? Because before this summer school, I hadn't understood that there is a possibility that actually proposals are not taken into account, that the Commission will drop some of the tools that have proposed. If an agreement is not reached. So maybe we could ask you to give us your views on the future of the pact.
So on the content or on what I expect, what will happen?
Yeah, more, yeah, what you expect will happen, more from the negotiations point of view. Thanks.
We already touched that. Is there one or another more quick question? Because that will be the last round. I don't see anybody. Ah, yes, Caroline Pop again.
No, I just wanted to know if you could spell out the website that you mentioned earlier, because we didn't catch that. That's all. Thank you.
We will look for that also, and we will circulate it to all the participants of the summer school, because indeed it deserves to be more known. So that was just a remark of Caroline. Is there another question? No, it doesn't seem to be the case. So Tineke, we come back a bit to the issue that you already touched, your feeling about the future of the pact. What do you want to add about this?
Yeah, I think it's a realistic scenario that the whole pact will fail. That there are hardly negotiations at the moment in the council. We still have to start. I can imagine that if even member states cannot agree among each other, we can never start the negotiations between the Parliament and the Council. The same happened with the previous pact, and I think where the Parliament had a position on every file, but we did not enter into a trilogue because the Council was not ready. And I have the feeling that the Council is now at the moment even more divided than it was by then. And the proposals also go much further than then, with this obligatory screening procedure and border procedure, which how it will work will very much depend on the national capacities, with no guarantees for border countries to be supported. Why should they accept this? I mean, why should they enter in this without sufficient guarantees? And I think the only way it could work if member states would decide to agree on more guarantees on relocation. But then it will come on the question, do we have sufficient member states prepared to do so? And can the Visegrad countries block, are they a blocking minority or not in that regard? And there you see it's not only anymore Hungary and Poland or Slovenia, more and more countries tend to choose their side. So if they do not agree, yeah, there will be just a deadlock, and then we end up with no possibilities. And what you see is more and more coming up. Shouldn't we, if we cannot agree to a better system in this current, communitarian system, and I think one of the causes that there's more and more division is that member states start to think more politically and more intergovernmental instead of going more into communitarian decision making. But I think the only way forward would probably be that we go another step towards communitarization. For instance, that there should be EU registration, EU screening, EU procedures, EU solidarity. That I don't see it happening, if we stick in this division, that we will find a solution without thinking more federal in terms of solutions. But we're not there yet. It's interesting that in Germany, the idea is growing. Also for the agency, for instance, that they wanted to give the agency more competences. With Frontex, you will see exactly the same difficulty, that the limbo of it's the host member states, that can authorize Frontex, but we have a specific obligation for Frontex if it comes to fundamental rights, but they cannot fulfill it because the host member states, really don't want them to do so. I mean, of course, Frontex, you can blame Frontex for a lot, but you see that the system doesn't work if it's a hybrid, actually. It's on the one hand a little bit intergovernmental and on the other hand a bit communitarian. So maybe if we will face a new deadlock, we have to think more radically on the system itself, because otherwise we will never get away from this. And therefore I said at the beginning, let's in the meantime at least make sure that the current rules we have that are not so bad, the recast procedures directive, the qualification directive, the reception conditions, with a lot of good standards. Let's at least start working on a better compliance of the rules we have.
Thanks a lot, Tineke. We will close it here. That's a very interesting perspective, because when we put everything together, we can say that we have an external solution, an internal deadlock, but then you call for maybe an institutional brainstorming in order to see how to go forward with actually more Europe, but more institutional Europe.
Exactly.
Through agencies. So that's another way of interesting thinking for the future. So let me thank you warmly and sincerely for having devoted us so much of your time this week. We are really very happy and proud that you accepted to spend so much time, and you really enlightened us, I think, on some issues. I think that the participants of the summer school already said that we all now better understand what is at stake with the pact, and that actually that it could fail. So we wish you a very good day and a successful intervention in plenary, which will happen if we are well informed. We will certainly follow your work through indeed your website on the Parliament, but also through the Inside Out website.
Thank you very much. Oh yeah, that's tineke.strik.eu. So very simple.